All right, hello everyone. Welcome to Comparing Legal Approaches to Accessing Psychedelics. My name is Carmel Shachar, and I'm the Executive Director of the Petrie-Flom Center for Health Law Policy, Biotechnology, and Bioethics at Harvard Law School. I think this is a particularly interesting event. I think of it as there are so many different doors by which we could access psychedelics. Some people really want to take the medical door to say we should be promoting research or even utilizing certain policies like right to try or expanded access. Others advocate for taking a look at non-medical pathways, including reducing criminal penalties or creating new regulatory systems. This panel is going to have a really thoughtful discussion about these different doors, which doors we might want to go through. Speaking of moderated discussion, because this is going to be a discussion and not a series of presentations, we not only welcome your questions, we strongly encourage your questions. The best way by far to submit your questions at any time is to use the Zoom Q&A feature found in the meeting controls at the bottom of your screen. Our moderator will be reviewing all of the questions and be keeping a close eye on the Q&A feed. You're also welcome to join the conversation or to submit questions on Twitter. We're at Petrie-Flom. Please use the hashtag Poplar. Again, that's hashtag Poplar. We will be sharing the fully captioned event video with everybody registered, so you all, but other people who registered for the event within 1 to 2 weeks. And we strongly encourage you guys to share it with your friends, any Twitter followers or the like who might be interested. If you have any technical issues, and I sure hope you don't, please email us at petrie-flom@law.harvard.edu. Again, that's petrie-flom@law.harvard.edu, and we'll do our best to resolve your difficulties. If you find this conversation interesting, by far the best way to know about our other events is to sign up for our newsletter. It comes out only twice a month, so it will not flood your inbox. Please also consider reading Bill of Health, our blog that translates cutting-edge health law and policy research into accessible topical posts, as well as you can use the final QR code to check out our upcoming events for the spring. With that, I want to introduce our moderator for this event, Mason Marks, who has an MD and a JD, is the Florida Bar Health Law Section Professor at Florida State University College of Law, as well as the Senior Fellow and Project Lead on the Project on Psychedelic Law and Regulation here at the Petrie-Flom Center. Mason, the floor is yours.
Thank you so much, Carmel, and welcome everyone. Thank you for joining us for Comparing Legal Approaches to Accessing Psychedelics. As Carmel mentioned, we welcome questions from the audience, so please do submit those through the Zoom Q&A feature. You can find that at the bottom of your Zoom window. If you don't see it, you might have to click on a little button with 3 dots to find the Q&A feature. Just type your question there and I'll be monitoring that throughout the event, and I'll pepper your questions in with the questions that I ask of our panelists. Before we get started, I want to thank the Petrie-Flom Center staff, specifically Chloe Reichel and Laura Chong, for their help organizing this panel. I also want to acknowledge the generous support that we've received from the SciSay Foundation, Tim Ferriss, and Matt Mullenweg. With that, I want to launch into our event. When I reflect on the past few years, I'm really struck by the pace at which psychedelic drug policy is changing. It was not that long ago in 2019 that Denver became the first city to reduce criminal penalties associated with psychedelics, specifically with psilocybin-producing mushrooms. And since then, over a dozen cities have followed Denver's lead. Major cities across the country like Washington, D.C., Seattle, Washington, San Francisco and Oakland, California, Ann Arbor, Michigan, and several cities in Massachusetts. And the following year in 2020, Oregon became the first state to legalize the supervised use of psilocybin. That's a psychedelic that occurs in many species of fungi. Colorado recently passed its own law that has many similarities to Oregon's Measure 109, but also many important differences. And there are now over a dozen states that have either proposed or enacted similar legislation. And they come in a variety of forms. Some are specifically for medical use of psychedelics. Others allow for non-medical, non-therapeutic use. And it's unclear how some of these laws will intersect with federal law, under which psychedelics remain heavily restricted as Schedule I controlled substances and are not FDA approved for any medical purposes. Needless to say, there's a lot happening. And on top of all that, at the state level, we're starting to see enthusiasm for psychedelic legal reform at the federal level. A national psychedelic task force is forming in Washington, D.C. There's a new congressional caucus on psychedelic medicines, and Senators Booker and Paul recently introduced the new Breakthrough Therapies Act, which we will discuss today. And importantly, many are concerned about how traditional and indigenous religious, spiritual, ceremonial use of psychedelics fit into this picture. How can they be integrated into these state laws? Should they be integrated into these state laws? And how should they be approached at the federal level? They are already, but perhaps there are ways to improve upon that moving forward. We've assembled a panel of experts on various facets of this emerging psychedelic ecosystem. And I now want to give the panelists 2 minutes or so to introduce themselves and to give us a sense of what perspectives they bring to this conversation. And I think we'll go first to Allison and then next to Holly. So welcome, Allison.
Thanks, Mason. I'm Allison Hoots. I am an attorney and I am of counsel at Plant Medicine Law Group. I work in the areas of employment, business, tax, intellectual property, but specifically focused on psychedelic companies, as well as churches that engage in ceremonial use of psychedelics and other substances. I'm also on Chacruna's, the Chacruna Institute's Council for Protection of Sacred Plants. It was there that I wrote a guide to the Religious Freedom Restoration Act and best practices for psychedelic plant medicine churches. And I'm on the board of directors and an officer for the Sacred Plant Alliance, which is an association of churches that are working toward best practices in the space and ethics. And I also work with a church that is sort of how my whole story started. I'm on their board and I'm an officer, and I've been helping them operate for almost 7 years now.
Great. And my name is Holly Fernandez Lynch. I'm a lawyer and ethicist by training. I'm an assistant professor of medical ethics and law at the University of Pennsylvania. And my work focuses on clinical research ethics and regulation, as well as FDA pharmaceutical policy. And at the intersection of those areas between research and treatment use, I do work on pre-approval access to investigational medicines through a variety of pathways now. The one that gets the most use is the expanded access pathway. And then there's also something called right to try, which we will hopefully have a chance to talk about today.
Thanks, Holly.
Hi, my name is Brett Waters. I am the co-founder of Reason for Hope, a nonprofit organization focused on providing safe and affordable access to psychedelic medicine and assisted therapies. Also the co-founder of the recently formed Veteran Mental Health Leadership Coalition, which is like an association of all of the veteran service organizations in the space who have been helping veterans access psychedelic medicines outside the country or through religious use frameworks, as well as all of the or many of the veteran providers and researchers, both within the VA and outside the VA. I am an attorney. I was doing antitrust litigation at Winston & Strawn in New York City for the last 5 or so years, and just left the firm last week to focus on this full time. So thank you for including me here.
Thank you. I want to start off talking primarily about traditional pathways to access. So the FDA approval process to create approved drugs and medical devices. We have a couple psychedelics that have been in that pipeline for many years. Psilocybin is, by most accounts, a couple years away potentially from becoming an FDA-approved therapy. MDMA, which some consider a psychedelic, others do not, perhaps a year or two away. I wonder if I could ask you, Holly, and anyone else who wants to weigh in, tell us a little bit about this process, why it's important, what do we learn from the FDA approval process, and why is that an important approach to accessing these substances?
Sure. Well, I will focus on the medical uses, not the ceremonial uses. And the reason for that focus is that's what FDA, their jurisdiction covers, medical uses. And sometimes when we talk about FDA, and you ask people, why does FDA exist? The very cynical response is, it's government paternalism, and, they exist to stand in the way between, doctors and patients who just want to decide for themselves which treatments and, therapies to use. There is a bit of paternalism in the sense that FDA is responsible for evaluating safety of products. But really critically, FDA plays a role in information production by forcing companies to conduct clinical trials, to generate evidence about their products and the safety and effectiveness of those products, that the market is unlikely to encourage sufficiently companies to develop on their own, right? So if we look at the difference between nutritional supplements and what we know about nutritional supplements versus, clinical therapies that are regulated as drugs by FDA, the amount of information that we have between those two types of products is vastly different because the requirements that FDA imposes are vastly different. So, sometimes people say, well, the market might be able to work this out on its own, to which I think the strongest response is, even if that were the case, it is very helpful to have an expert agency that is able to parse through the data in a really rigorous way that patients and clinicians either lack the time or the expertise to do on their own, right? So if you think about your clinical providers, no matter how expert they are, it would be very challenging for them to know, like the back of their hand, the data that would support all of the different drugs that are in their, their therapeutic area that their patients may need. So what FDA can do is serve as, a bit of a good housekeeping seal of approval. If we have a trustworthy FDA, then both patients and clinicians can say, I don't have to go through these data myself. FDA has done that, and I can trust that this product is safe and effective. What I mean by safe and effective is, that the benefits outweigh the risks of this product. And so really, FDA has this information forcing function that I think is quite critical, that all patients and clinicians really benefit from.
You mentioned, so there's the information function, which I've observed that some states are trying to build into their psychedelic legislation. So there are efforts in Oregon to collect data from clients who are administered psilocybin. There are similar mechanisms built into Colorado's Proposition 122. How might these state level efforts to collect data mesh with this information function that you describe that the FDA provides? Like, are they compatible?
So I think they're compatible, but I don't think one will be a substitute for the other. And it really depends on what kind of evidence production is intended or the goal of these state level efforts. So sometimes there's lots of different types of evidence, right? There are randomized controlled trials that allow you to draw causal claims and have more confidence about the claims that are being made about a product. And then there's observational studies, and then there are registries, which is a type of observation. And so you can imagine a spectrum of evidence in which placebo-controlled randomized trials are the gold standard, and kind of case reports are, the other side of the spectrum. Now, doing placebo-controlled studies in psychedelics is very challenging for obvious reasons. You tend to know when you've gotten the psychedelic intervention. But there are still ways, right, to do clinical trials in ways that try to minimize noise. And what I mean by that are other variables that might influence people's outcomes. Observational studies are better than not gathering any evidence at all, but are not as good as studies that have really well-matched control groups and involve some kind of randomization. Because if you're just observing people, those who find their way to psychedelic therapies are going to be in many ways different than those that don't find their way to psychedelic therapies in their mindset, in their access to care. All types of things could be different about them, where they're getting their care. And so observational data is going to be weaker in terms of getting us that evidence about what actually works, what are the settings that are most beneficial. And those things are important not only for patients and clinicians who are deciding which therapeutic pathways to pursue, but also to payers who have to make judgments about what they are going to be willing to pay for.
I want to turn to you, Brett, because you're part of an effort to reduce some of these barriers that Holly alluded to in doing the research on Schedule I substances. So could you tell us a little bit about those efforts?
Sure. So Holly is describing here mostly all FDA regulations, and the additional burden that psychedelics are unfortunately facing here is the Controlled Substances Act, and particularly Schedule I of the Controlled Substances Act, which makes it incredibly difficult for researchers just to be able to access the drugs that they need to study for medical purposes. And so what the recently introduced Breakthrough Therapies Act is doing, and some people may have seen some what I believe to be very misinformed criticism of it published the other day. What it's actually doing is going after the Controlled Substances Act barriers, not the FDA. And so the first substantive section of the act is just reducing the barriers to be able to research. And that section was actually something that was proposed by the Biden administration, all the relevant agencies about a year ago, and has shown up in some other legislation. Most significantly, it's making it easier for researchers to get their registrations to work with Schedule I drugs, aligning it more closely with Schedule II. The second section of that bill would make it easier to reschedule Schedule I drugs to Schedule II by defining what it means to be a currently accepted medical use with severe restrictions under the Controlled Substances Act. And that's really important to understand, because that is the initial definition that has to be met to go from Schedule I to Schedule II. And the way that the Controlled Substances Act works in practice, although it was not necessarily designed to be this way, is the only way out of Schedule I is FDA approval. So what this is doing is making it easier to get that rescheduling from Schedule I to Schedule II before FDA approval by relying on either the FDA providing a breakthrough therapy designation or an expanded access approval to Schedule I drugs. And that would apply right now to both MDMA and psilocybin. So that is essentially what is being proposed under this bill would be a very limited change to how people are able to access these drugs for research purposes, and even like expanded access, which is research-based treatment, still requires having to go through that the registration process under the Controlled Substances Act. That if this was just a new drug being developed by a drug company, but it wasn't, psilocybin, MDMA, or another Schedule I controlled substance, it wouldn't face that additional barrier.
I want to circle back to expanded access and some other pathways like right to try, which is another avenue through which physicians have tried to get access for patients to psilocybin. But I first want to ask you, Allison, we're talking about the Controlled Substances Act, which regulates psychedelics as Schedule I controlled substances. What barriers does the act pose to indigenous or religious communities that want to access psychedelics, and what options are currently available to them?
Right. So, I mean, it is just that, Mason. It is a barrier where these substances are scheduled on the Controlled Substances Act at all, to the degree that, the uses in a ceremonial context are illegal. The only real way, the only legal way would be to have an exemption from the DEA. And this has been incredibly complex because of a lot of misinformation that's out there, and also just trouble understanding the actual information, which is that there are a few churches. There are 2 churches in the United States, well, 2 religions with 4 churches, but the UDV and the Santo Daime, who sued the government back in 2006 and I think 2009, and succeeded, where they were able to demonstrate that their religious exercise with these substances were protected because they were burdened by the Controlled Substances Act using this federal law, which is the which is RFRA, right? Oh my goodness, which is Religious Freedom Restoration Act, the brain fart. So that is the federal law. And there is also the state level versions of RFRA, which people cutely call mini RFRAs. But these 2 churches succeeded under federal, and that was because the actions of the government, which not only included the Controlled Substances Act, but substantial actions, as it has to be a substantial burden, which was seizing their sacrament or threatening to prosecute them, was so much so that they were unable to engage in their religious exercise, and the government wasn't able to demonstrate that their interests were being furthered by the Controlled Substances Act. And that's really important, I think, especially in the context of seeing these massive leaps in Colorado, in Oregon, and these medical uses, because the 2 government interests that were identified that should have, in the government's argument, overridden this religious right to use the controlled substances were the right to protect participants in these ceremonies, right? Their responsibility to protect the citizens of the United States from these substances, and they needed to prevent diversion, so diverting the religious use of these substances to other uses. But where we're seeing these huge changes in the landscape in the medical and in the recreational areas, a lot of these government arguments are being minimized, if not eliminated. So where these churches succeeded back in 2006 and 2009, suing the government for exemptions, I think there is a greater potential currently to seize those successes where the analysis has shifted so much so because of the change in the perspective of the use of psychedelics and the decrease in the stigma in the use around psychedelics. And so what we are seeing is a lot of churches learning that if they incorporate and they operate according to best practices that I think you can see that were established in those cases with the UDV and the Santo Daime, that they're legal. That's not true, but instead what they're doing is establishing themselves and preparing themselves for claims or defenses under right to religious exercise laws such as RFRA, mini RFRAs, and even under state constitutions where there is a right to religious exercise. And so, where there really isn't a very accessible route to exemption through the DEA, we had an application by SoulQuest that they were unresponded to for many years and then sued. And long story short, they were denied their application for a variety of reasons, some of which I think are potentially justifiable and some were not. But my point being that no one has actually gotten an exemption approved through the application process that the DA has put out, saying it's available, but hasn't really been engaged in by the government in any way that I think is creating the authority they claim to have. And last year or this year, the beginning of the year, they had said they were going to open to comment period on that process. That never happened. So while there is this alleged way to access an exemption, it hasn't really been utilized or utilized successful. And so I think the way many psychedelic churches and ceremonial use of psychedelics is happening in the country now is this sort of tenuous gray area operation where they're operating, assuming they're doing it by the correct standards. And in my opinion, if they've done it in a certain way, are really set up to best succeed in court. There really isn't any legal certainty. Ultimately, it is and remains illegal federally. But we are seeing in some states, Oregon is highly regulated, hasn't really created space for religious use, but Colorado, we are seeing some space. But what we're going to have to do is wait and see as these communities may get more public, are operating in grander scales, what's going to happen with rulemaking and how authorities respond.
It's interesting that there does seem to be a misconception that these churches have a right, or that or a right that's very easily obtainable, if not a right that already is very clear, and that really isn't the case as you are describing.
They have the right, but that doesn't mean it's legal, and I think
right. So they you could argue that that there's a constitutional right exists, and but that has not ever successfully been advanced since RFRA, has it? Like, usually that's what these arguments have been based on. There haven't really been efforts to clarify that there's a right to free exercise under the First Amendment. Like, that's sort of still an open question.
Right. All of these arguments have been formulated under RFRA, and RFRA basically defines the test of government action and how it affects religious exercise. So I suppose in a way it has been shown, they had this right to religious exercise, and RFRA said it has to be strict scrutiny, which just means the highest scrutiny of government action where it substantially burdens religious exercise. However, we did see in a recent case with an individual named Mac in New Hampshire, where he did invoke a state constitutional right to religious exercise, and the court acknowledged it without any mini RFRA in that state. So without strict scrutiny being clearly required, it was suggested by the way the court put it back down to the district court to review that these rights can just be derived from the Constitution, which is huge, especially for states without mini RFRAs. Because to be clear, RFRA was refined in such a way in a case, Bourne v. Flores, that only applied to federal actions. So that would only mean acts by federal agents, such as the DEA, Homeland Security, FBI, was protected by RFRA, and only state action is therefore protected by mini RFRAs. So if you had your state police coming to a ceremony and getting involved or seizing sacrament, federal RFRA wouldn't apply. So what's really amazing about that case, Mac, was that we're seeing that you can derive these rights and have protection and then raise these defenses or file a claim stating you have religious rights to religious exercise. And if it's sincere and it meets a couple of other criteria, such as, there isn't harm to participants, you're not diverting your sacrament into a recreational use, then you should be able to argue that your right has been impinged.
I want to return to how these issues might be addressed better moving forward by states, perhaps, through legislation. But I want to jump back first to these access pathways that exist. The FDA has created pathways. Well, the FDA oversees pathways, I should say, like expanded access and the Right to Try Act, which physicians in Washington have been attempting to use as an avenue for providing psilocybin to people toward the end of life. That's physicians like Sunil Agrawal at the Ames Institute. So I wonder if we could talk a little bit about what exactly is Right to Try, what are they trying to achieve, what's the status of that? There was a lawsuit, but what is Right to Try, and is it a good thing? Are there concerns associated with that?
Do you want me to take that, Mason?
Sure.
Okay. Well, to understand Right to Try, you have to understand expanded access first. So expanded access is a pathway that FDA did create in response to the HIV epidemic in the late 80s and early 90s. And it allows patients who are unable to participate in a clinical trial to nonetheless access investigational treatment options. So you have to, under these regulatory provisions for expanded access, you have to be facing a serious or life-threatening disease or condition. It has to be the case that the benefits, the possible benefits of you taking that product will outweigh the risks. It has to be the case that you have no comparable an adequate alternative treatments. It has to be the case that you are not eligible to get that investigational product through an existing protocol or IND, meaning you can't be in a trial. And FDA has to have determined that allowing the expanded access will not interfere with clinical development of that product. So basically, those last couple of points are just to make sure that we are not siphoning participants away from clinical trials that would help generate the evidence about safety and effectiveness that are necessary to get FDA approval, because getting FDA approval is how you're going to get the product to many more patients who could potentially be benefited from it. FDA says yes to individual patient expanded access requests almost all of the time. You can request expanded access as an individual, as a small group, or as a wider group of patients. The more people are getting expanded access under a particular protocol, you need to provide more promising evidence that the product is likely to be effective. So FDA is almost always saying yes. Companies might say no for a variety of reasons, including money. You cannot profit from expanded access, although you can charge your direct costs. Or they might think, this product is actually unsafe. There's a reason these people couldn't participate in the clinical trial. A variety of other reasons that a company might say no. The other kind of barrier to expanded access is that people might not know about it, right? Clinicians may not know that this is an option. Patients may not know that this is an option, but it is. It is an option. Right to try is an alternative to expanded access that cuts FDA out of the process. Interestingly, it is a revision to the Food, Drug, and Cosmetics Act, but you do not need to get FDA sign off for right to try. It's a little bit different from expanded access, whereas expanded access is available for serious or life-threatening condition. Right to try is limited to life-threatening conditions, this was a movement, the Right to Try movement, which initiated through the Goldwater Institute, which succeeded in getting 41 states to pass their own state level right to try laws. And ultimately, Trump signed a federal right to try law in 2018. Now, the other really important thing to acknowledge about right to try is that you have to have a product that has under IND, an investigational new drug application, and has gotten past phase 1. Now, very briefly, why many of us in bioethics were worried about right to try was that it's not actually a right to try. Companies can still say no. And by cutting FDA out of the process, you're actually going after the wrong targets, because remember, I told you that FDA almost always says yes to expanded access requests. So it really didn't strike us as something that was going to be beneficial. And it turns out not to have been beneficial. It is barely being used, despite very extravagant claims of how many patients were going to be helped through the right to try pathway. Now, how does this come up in the context of psychedelics? Well, Mason mentioned this litigation that's happening in Washington State, where a physician, a palliative care physician, would like to provide psilocybin, I think it's psilocybin, right, Mason? He'd like to provide psilocybin to terminal cancer patients to address anxiety and depression. Now, providing psilocybin for this purpose could fit under either expanded access or right to try. This, I mentioned it can only be a life-threatening disease or condition for right to try. Interestingly, the psilocybin would not be provided as a treatment for the life-threatening condition. It's that those patients are eligible because they have a life-threatening condition, and ancillary to that is what the psilocybin would be used for. They apparently have a company lined up whose specific product is under IND and has gone through phase 1. So they have eligible patients, eligible drugs, right? It fits the right to try conditions. And so what the physician did was send a letter to DEA and say, how are you planning to accommodate the right to try law? I would like to use the right to try law to provide this product to my patients. So how are you, DEA, planning to accommodate it? To which DEA said, we're not planning to accommodate it because right to try only, as a statutory matter, makes exceptions to the Food, Drug, and Cosmetics Act. It does not make any exceptions to the Controlled Substances Act. So interestingly, the physician in the initial letter to DEA said, what should I do? Should I register as a researcher? Like, what pathway should I use for this? And DEA said, you should register as a researcher. To which the physician said, no, that is not an acceptable pathway. And now, this has been engaged in some drawn out litigation in the Ninth Circuit, which, sent the case back down on procedural grounds that the DEA had not made a final agency decision about how it was going to handle right to try. It had only given advice or guidance about what to do. It had not enforced the Controlled Substances Act against this physician. The physician then asked nicely for a final agency determination to allow the federal courts to be able to make a decision in the case, and it is still pending. Now, my concern about the case is that statements that are being made about it suggest that DEA is preventing these terminally ill patients from accessing psilocybin, which is not true. There are pathways for these patients to gain access. They could go through expanded access. They could go through right to try if you got the right DEA authorization, right? So there has also been subsequent proposals, legislative proposals from Paul Rand and Cory Booker, interesting bedfellows in the context of psychedelics, who have put out a right to try clarification bill that would not only exclude FDA from overseeing the right to try process, but would also kick the DEA out of this as well. Now that has not been enacted yet. That would resolve this particular issue. But I want to be very clear about the fact that there are pathways for patients to access these substances that could potentially be beneficial to them through either expanded access or right to try. Now, to be fair, right, it is not research. Neither right to try nor expanded access are intended as research uses. They are intended as treatment uses. So technically, I could understand the physician saying, well, I shouldn't have to register as a researcher. I am not doing research. Nonetheless, this is work that would be happening under an IND. Expanded access is not research either, but when you provide expanded access for a DEA controlled product, you have to get those registrations. And so it's no different. This right to try process versus expanded access is no different on the Controlled Substances Act side of things. So I worry a little bit about the some disingenuity here about, we could provide patients with access to these products. There are barriers in place. We could argue about whether those barriers ought to be in place, but there is a path forward here.
Brett, did you want to?
So, well, I'll respond on the Right to Try Clarification Act, which my understanding of the response from DEA and the Department of Justice is, it was not favorable. They don't like to go up their jurisdiction, for anything. And so what they were open to doing though was to creating a pathway that they don't want to prevent people from getting potentially life-saving medications, that have enough of evidence on the risk safety profile that suggests that they should be able to access it in certain situations. And so the DEA actually is open to helping provide that pathway, and that's really another component that I think is not necessarily understood about the Breakthrough Therapies Act, is that that is essentially creating that pathway. What it does is it keeps these drugs like MDMA and psilocybin that would be eligible within what the DEA refers to as like their closed loop system of regulation. So you still have to get the registrations, but you wouldn't have to go through the FDA process. And that is really the difference, that the DEA, from the DEA's perspective, they still want it, the drug distribution and prescribing to remain within their purview. So the Right to Try Clarification Act was pretty unpopular on probably both sides of the aisle politically, was not popular with the DEA. The Breakthrough Therapies Act essentially supersedes that.
Could you tell us a little bit more, Brett, about how expanded access fits into the picture? I have been very interested in the Connecticut psychedelic bill that will allow people to access substances through it leverages this expanded access pathway. And so, why is that an appropriate means of accessing psychedelics? Is that preferable to Right to Try? If so, what's beneficial about it, or other pathways?
Sure. So the expanded access, obviously has that additional FDA and IRB oversight that some people would prefer that we just get rid of. In Connecticut, the preference was to not go outside the bounds of what the FDA would allow. And so this was a way to provide funding potentially for a very unique form of therapy that has not ever been approved by the FDA before. This is not just MDMA coming through, but an MDMA assisted therapy, same with psilocybin. And so there is an element of this that is about infrastructure building, that we need to make sure that we have people who are trained and licensed, credentialed, that we have the proper setting setups, that clinics, there could be a variety of different locations that this could be done that already exist, but there's going to need to be some development work that helps with the rollout of these therapies. So once the FDA approval comes, it's not a matter of just, who's going to provide this, where do I get it? And really that's where, when you see kind of off-label use of ketamine, I think it could create a lot of risks if we don't have a good plan in place for who and how this treatment can be provided in medical contexts. And that's really what Connecticut, by establishing a pilot program, can provide funding for a lot of these things to more slowly start to integrate and learn about how this treatment can be provided. I know that it was kind of discussion that it isn't research necessarily, but there is safety data collection that's required to be submitted. And Epidiolex, I think, is a good example of what was a Schedule I drug before FDA approval, that there was a 38-site expanded access program for Epidiolex. That's a lot of patients who were helped, and had about half the safety data supplied to the FDA that helped with the approval of that drug. And certainly the safety data that's generated through this sort of program can be very helpful. It can also inform payers and state regulators for how this treatment, how tightly or who can provide the treatment. And there's still some uncertainties with FDA that are going to be, play into these considerations. And I'll kind of add that this was a big reason why we engaged the Department of Health and Human Services as a whole, not just the FDA from the beginning, is that the FDA traditionally does not regulate the practice of medicine, or particularly therapies. And so that's something where really getting guidance from HHS for states to be able to implement or adjust as they need to can play like a huge role in helping to speed up implementation of these therapies in a medical context.
Since you raised HHS, we had a question from Ron McNutt in the Q&A regarding HHS, the Department of Health and Human Services. Has anyone seen any mention by HHS, or maybe other federal agencies, toward religious use? And what does this come up in federal level conversations about psychedelics, and how medical use might impact religious use, or vice versa?
Oh, Allison, you can go ahead.
Okay. I was going to say yes. We are seeing the government starting to organize in such a way that it does want to have conversations with groups that are longtime ceremonial leaders in the space. They want to learn from what the churches who have received exemptions are doing, because these are indigenous practices, traditional practices that have been engaged with for hundreds of years, and they've done it in such a way that's safe. So I think that what's happening right now is we're starting to see a little more of a balance in the government, and also potentially medical side, trying to learn from the religious use sphere. And I know there are some groups, I think SAMHSA had a group that's together now that is speaking more to these traditional practitioners. I think that the way that we're going to see the best advocacy for religious use in the United States is good practitioners implementing best practices. Because if we end up implicating some of the government interests, such as risk to the health and safety of participants, or using the sacrament in such a way that's problematic, that could be blasphemy or redirecting it for other uses, then we're going to set bad case law. And that's where religious use is deriving most of its protection right now, is this good case law from the UDV and the Santo Daime. And other cases, even like Hobby Lobby, where how religion is defined is highly ambiguous, but the courts almost said it's not up to us to say what is a religion or not in the Hobby Lobby case. So we're seeing more and more just RFRA cases, even having nothing to do with psychedelics, developing law that is helpful to the religious use. And the government seeming to be very interested in understanding what proper, safe ceremonial use looks like, and potentially, whether this is a good or a bad thing, developing their own standards and how they will analyze it in the future, which hopefully would lead to actual legal pathways for these sincere groups that are doing things the right way and have actually set the foundation for a lot of this medical use. And I think that's important to acknowledge and honor.
We have a question from an anonymous attendee regarding the Federal Analog Act and how that might fit in with the Breakthrough Therapies Act. The Federal Analog Act makes it easier to schedule drugs that are their chemical structure is similar to an existing Schedule I substance. So it's kind of guilt by association. They have an analogous chemical structure, and so they can be placed in Schedule I. And so I guess that's sort of a pathway into Schedule I. Breakthrough Therapies Act might be a potential path out, but I think you would still have to do you'd have to go through some initial steps with that analog before it would be, well, I guess the research would still be easier because of the registration, lifting some of the registration requirements. Is that right, Brett?
I'm sure, are we talking about for drugs that are on Schedule I because of the federal, or how it might impact putting, like, I know this is sort of part of the issue that's tied up with the class-wide scheduling of fentanyl-related substances, that the Analog Act already exists, but there is, having to kind of prove each different analog on a case-by-case basis is why there's this attempt to permanently schedule them class-wide as substances. So I think I'll have to go into the chat and take a look at what the
maybe add an analog act to the clause to the Breakthrough Therapy Act, so any analogs are automatically taken out of Schedule I into Schedule II. So it's I think I've previously expressed some concern with how easy it is to put drugs in Schedule I, and this Analog Act is one means of doing that. So it's interesting to think about how that would allow analogs to flow into Schedule I. Breakthrough Therapies Act would allow, one specific chemical to leave potentially if it meets the requirements, but those analogs would remain in Schedule I purgatory.
So the language does include, and maybe this answers the question that was asked. It does include language getting at the active moiety or active ingredient of the investigational drug. So it actually, whether natural or synthetic. So, what that is doing is obviously psilocybin, I think, is in particular, the drug that a lot of people are concerned about, that even if FDA approval comes, psilocybin itself might stay as Schedule I, and that this may be a method by which it gets out of Schedule I, where currently it doesn't appear that one exists outside of legislation. Oh,
okay. So you're saying that if there's a formulation that becomes FDA approved, like Comp 360 formulation, because it's the active moiety, the psilocybin chemical in that approved therapy, the Breakthrough Therapies Act would allow psilocybin itself to be rescheduled, even though that's not the therapy is a more sophisticated sort of formulation of psilocybin?
I guess all I can do is speculate that that could be the result. I believe most people think that even when MDMA is approved, like that MAPS MDMA will be scheduled as a new drug product. MDMA will remain Schedule 1. Compass and Usona psilocybin will get FDA approval. That will be scheduled as a new drug product. Psilocybin will remain Schedule 1. So then the question becomes, how do you get out of Schedule 1 ever, if that's the case? And this is potentially a means of addressing that. But I think we'll have to see how it, if it were to pass, how that plays out.
So we're seeing a huge variety, just as we're nearing the end of our time, but we're seeing a huge variety of different approaches here. There are the state level laws like Oregon's Measure 109, Colorado's Proposition 122. There were efforts in Oregon to create rules that might be welcoming or accommodating to religious communities. It seems, at least so far, as though that hasn't proven successful. So many are concerned that these state level systems might be somewhat hostile to religious and indigenous communities and their approaches to using psychedelics. So how might that be done better? I know, Allison, you mentioned that Colorado's bill addresses this in some ways, but what would be a good approach for future states perhaps to consider?
Well, I think one thing we can look to was, after RFRA was passed, which, did ensure this certain kind of protection of the right to religious exercise, that was, problematic in the courts previously in the Smith case. They did also pass the protection of religious use of peyote for Native American communities, the Native American Church. In Colorado, they have a state level law that allows use of peyote for any bona fide religious use. So it's interesting that, there are these protections for peyote and not for other substances like psilocybin or ayahuasca. And so, of course, there's an important reason why, which is the long-standing traditional use of Native Americans. But at the same time, there's an equal protection issue, which is that religions that use other substances that ultimately have the same level of safe use, and we're seeing that documented in these medical studies, and there's only certain kinds of regulation that is implemented by the government, that needs to be reflected. I think there's only so much that can be done by the states in terms of regulation, but I think a lot of the standards are there in the cases, just about health and safety and the storage of sacrament. And if that's what they're willing to limit their regulation at, I think it's appropriate to have laws in place that do so. But, there's a lot of risk in that reward when you have the government regulating religious practices to some degree. And I think that's what is problematic in Oregon, is they only wanted religious practices to happen in these therapy centers. So it remains regulated in a medical model, which I think is out of alignment with religious practices and sincere religious beliefs around these substances, these sacred plants and other substances. So I think there's a lot of development that needs to happen there. There needs to be development of model language for states to implement. I know that I'm part of the religious use committee for the Psychedelic Bar Association. There's talks about doing some of that there. Sacred Plant Alliance is also talking about it. A lot of groups need to actually get it together and start to share that language and what would feel appropriate from the side of practitioners in terms of where they want to meet in the middle.
we are running out of time, so I want to thank all of our panelists and all of our attendees. This obviously is far too vast a topic to even scratch the surface in an hour's time, but I hope we've given you a glimpse of some of the different potentially competing, but hopefully not necessarily, approaches to accessing psychedelics. It remains to be seen how well they can coexist, whether states and the federal government can collaborate in creative ways to create access to safe, responsible uses of psychedelics. So thanks again, and please do join us for our next psychedelic related events. Have a great afternoon.